Let's speak to Liam Kotrie, who's director of Mary Monson Solicitors on Fleet Street. Liam, this is a very, very disturbing case. Good evening to you.
Good evening, Andrew. Thanks for having me.
It's a very disturbing case.
It certainly is. It certainly is. But the first thing we need to do here, Andrew, is look at the facts.
Yeah.
Now, I've seen several headlines here. I've heard different things that you've said in your opening tonight. But I think we need to look at the facts here.
Yeah.
What he's convicted of.
Yeah.
1 count of rape, a very serious offence, of course. I'm not downplaying that. 5 counts of sexual assault, 1 count of attempted sexual assault, and 12 counts something to do with some kind of administration of noxious substances. He was sentenced to 7 years imprisonment for public protection. Now, this means that after 7 years, he's eligible for parole. I can only assume, and I haven't seen any evidence of this, but I can only assume that he had a parole hearing after 7 years. That failed, and had another one after 8, because I believe it's been 8 years, and he's then been released. Now, that is what we know. We do not know what rehabilitation he may have received. We have heard that other complaints were made, 100, perhaps 200.
Yeah, that's a lot.
But it is a lot, and those complaints may even be valid, but they have not been proven in a court of law. Now, that is not his fault, and that is not the fault of the parole board. If there was enough evidence, and I stress if, to charge him with these further offences, then the police should have done their job and investigated the matter properly. If they gathered enough evidence for the CPS then to charge him, then he should have been charged with further offences and stood trial or been taken to court for those offences. But that's all that we can say at the moment. We can't start talking about him being guilty of having 200 victims. He may well have 200 victims, but this must be proven.
Yeah, I get that.
And that's a headline in the Daily Mail I've seen today, that he had 200 victims. No quotation marks, just that he had 200 victims. This has not been proven.
The point about, I think the point here is, there's two things. After his conviction, a further 75 women came forward to say they'd been victims of him. Now, one of the reasons we're told all the time that men accused of sex crimes are named in proceedings long before they're found guilty or innocent is so that other victims will come forward. Right. So here's a classic case. 75 alleged other victims come forward, and the Crown Prosecution Service at the time decided to take no further action. Shameful. Why not? Should that not be part of any inquiry that goes forward here, Liam Kotrie? Because if 75 come forward, presumably with similar stories about a taxi driver who spiked their drinks, there should have been a further police investigation and there should have been a further trial.
Well, when you say presumably with similar stories, if they are with similar stories, as you suggest, and there's 75 of them, well, that sounds like a pretty strong case to me.
Yeah, there's been
I would expect that investigation to be carried out and the decision made whether or not to charge. Yes, of course.
Now, the other thing is, of course, what he was sentenced to was an indefinite sentence. Now, it's the European Court decided what they're called an indeterminate imprisonment. Yeah. Now, these was because the judge didn't have his power. He said the charges did not meet the requirement of a life term, so he gave him an indeterminate imprisonment for public protection. The European Court, in its wisdom, decided these things are not fair, so the British government decided they had to get rid of them. So in the rush to get rid of these things off the statute book, this creature is being set free. That's what I would argue. And they've made a mistake.
I think you've misunderstood there.
Go on, tell me why.
Anyone who received one of these IPP sentences at the time, when this legislation was overturned or appealed, the IPP sentences were still in place. There are still people serving IPP sentences now. So the IPP sentence still exists if you were sentenced to it at the time.
Yeah.
And so it's not the case that the change in law has meant that he's been released. It's that the parole board felt that he was fit to be released. He's no longer a danger to the public.
So you don't...
These are experts.
Yeah.
These are experts.
I don't think experts are always right, Liam, actually. Liam, I don't think experts are always right, actually. I think experts...
We're only human.
Yeah, exactly. And I think
and we can't lock people up.
Yeah.
We can't lock people up just because we're not experts.
But you're saying the change in this man's status is nothing to do with the fact that the European Court of Human Rights ruled that indeterminate imprisonment for public protection in 2012 were a violation of the Human Rights Convention.
It has nothing to do with that at all. And to suggest something like that is misleading. While people may have misunderstood it, and I completely understand why they may have misunderstood it, because it's quite complex law, but it is completely wrong to say that anything to do with the European Court of Human Rights has made this decision.
I'm just reading what the learned legal brain Joshua Rosenberg says. The European Court judgment has no direct bearing on the Worboys case, but there's no doubt among many experts the authorities became aware of the need to empty jails of prisoners serving indeterminate sentences who'd gone past their minimum tariff. Worboys fits that category.
Well, let me tell you why I don't like these indeterminate sentences, and there's two sides to it. First of all, I believe it is against people's human rights to have a sentence where they don't know when they will be released. How can people work out how to rehabilitate themselves when they have no idea if or when they will be released? On the other side of the coin, people who are the victims in these cases should know at the time of sentencing how long that person's sentence will be. So you talked about this woman who I hadn't heard about, and it's absolutely awful that she's making dinner for her children and she finds out this man's being released.
Well, that's just one that we know about. That's just one we know about.
Of course. And it's the example that I'm going along with, as you said. She should have known on the day of sentencing when this man would be released. And if, at the time, it was felt that that sentence was too low, then she could have made her point at the time. Or the CPS could have made their point at the time. The Attorney General could have stated that the sentence was too lenient and put forward their case that way. So, that is what should have been done. And that's two reasons why these IPP sentences are just no good for anyone, either side.
OK. So a government source tells the Telegraph on their front page, it's not a sensationalist newspaper, about this decision by the Parole Board. This is a surprising decision by the Parole Board. He's in a Category A jail. To go from a Category A to release without being moved to an open prison first isn't unknown, but it's certainly uncommon. In these circumstances, the decision made by the Parole Board is binding. There's nothing the Secretary of State can do to stop it, but it's sending out a highly unusual and disappointing signal. Do you agree with that?
I wasn't aware that he was in Category A jail. That would have been something that would be dealt with by the probation service rather than the Parole Board, but I'm sure they will have been in contact with each other and should have been in contact with each other.
So he's not been in an open prison, he's been in a Category A jail, and he's going straight from a Category A jail to be released.
But what you and I, Andrew, don't know is why he was in Category A prison. We don't know what evaluations have been done of him. And I noticed the gentleman from the Parole Board, and I forget his name.
Hardwick, Nick Hardwick.
Nick Hardwick. And you talked about being blustering. I think he spoke pretty accurately about the system, and he's quite an accomplished person. I had read about him in my research for this interview. But it's important that both of those sides talk and everything is open. And he said the silver lining to this is that he will be working to make sure that these things are more open, because justice should be seen.
Yeah, there's nothing transparent about this. You don't know why he was in a Category A prison. Nobody knows why he's been released. Nobody knows why one of our worst serial sex offenders is being released after only 8 years. Nobody knows but the parole people who took the decision. Look up the Parole Board and try and get the names of the people who took the decision. They're nowhere to be seen.
Which is why, unfortunately, we have to speculate about what exactly has happened here, and much of our conversation here is based on speculation. But unfortunately, a lot of it is based on false information, which has been spread by the media over the last couple of days.
Well, I'm afraid it's the system's fault. If the system insists on secrecy, Liam, what do you expect?
Well, Andrew,
if you say media are getting it wrong, they're doing their best. But if the Parole Board won't even tell us who they are, so they can be held to account for their decision, and I think they should be held to account for their decision, because if I can't see for the life of me why this creep is being allowed out of prison. That's my instinct, and I'd like them to explain to me why my instinct is wrong, but I can't have that decision because it's secret.
Well, to go with the first part, and we were talking about whether or not to speculate here, you stated in your introduction that there should have been further prosecutions. Now, based on what? I mean, you don't.
Based on the fact so many came forward. Based on the fact so many came forward.
You've not seen the evidence, Andrew.
75 came forward. No, I know. I'm sure. I still think the fact if 75 women came forward and said "Me Too," I think I'd have had at least a look at it. But the CPS threw it out. Look, Liam, we've run out of time. I'm not cutting you off because of any other reason, but we are very overrunning for time. That's Liam Kotrie. He's the director of the Mary Monson Solicitors on Fleet Street.